Well, I think that's one of the biggest myths that we frequently encounter with people is that, and what they're confusing is another form of relief. There is something called cancellation of removal, which we've produced a video on that explains what you need to do to qualify for cancellation, but there are essentially 4 things. 1, you have to prove that you've been here for 10 years continuously. 2, you got to prove that you're a person of good moral character. 3, you got to prove that you have a qualifying relative, either a spouse, a parent, or a child that's a U.S. citizen or lawful permanent resident. And then finally, if you prove those 3 things, you are entitled to a hearing before an immigration judge to try to prove the 4th, that if you are removed from the country, that your qualifying relatives are going to suffer exceptional, extremely unusual hardship. What oftentimes happens is people just remember, well, if I've been here for 10 years or for a particularly long time, I'm going to somehow get an immigration benefit, and that's not true. It's more things than just being here for 10 years.
Well, that's actually a common myth. I mean, we have a lot of people come to us and say, you know, I've lived in this country for so many years, I've paid taxes, you know, we have children who were born here, we've worked here, you know, we've contributed to community, and unfortunately that alone does not create an opportunity for a green card. There is an avenue to apply for relief from deportation or removal through the immigration court. You have to establish that you've been here for at least 10 years continuously. So temporary absences from the United States may break that period of time. You have to establish that you've had good moral character for that whole 10-year period. You also, any significant criminal history may make you ineligible for cancellation. That would include things like a crime of moral turpitude, which includes a lot of theft and fraud-based offenses. And the last requirement, which is the most difficult for most people, is that you have to show that if you're deported from the United States, that your U.S. citizen or lawful permanent resident spouse, parent, or children will suffer exceptional and extremely unusual hardship. And it's a pretty high standard of hardship. So all 4 of those elements must be met, and the court must approve your case in the court's discretion. So even if you meet all of those requirements, then the court can still deny it in their discretion. There's also a cap to the number of those cases that can be approved each year. So 10 years alone of physical presence in the United States does not create an avenue for residency.